Hi, everyone. Nice to meet you for the first time. My name is Minji Kim. I am an assistant professor at Florida State University's Urban and Regional Planning Department. I am really excited to be delivering this first lecture of our second module. And this week, we'll be learning about how states have responded to the exclusionary zoning practices and to correct for the past discriminatory land use practices. I wanted to start this lecture by putting this particular lecture in the context of our overall class. So in the first module of the class, really, we walked through the history of discriminatory land use practices, including exclusionary zoning, but we also talked about how restrictive covenants and redlining practices, as well as planned unit development, have all worked in conjunction with each other to create segregated land use patterns. Last week specifically, we started to dip our toes into the strategies and movements against exclusionary zoning. And Professor Whittemore discussed the open suburbs movement, and Professor Gatz discussed the Fair Housing Act and the Operation Breakthrough, as well as some of the early court cases, including the ones that I will be discussing more in depth today. We are again entering into module 2, second module of the course, and for the next 3 weeks, we'll be delving deep into the strategies that have been developed and employed to redress exclusionary zoning practices. And we will discuss the efficacies of each of the different measures. This video in particular will focus on New Jersey's attempt to address exclusionary zoning practices by local governments. And I will do so through 2 New Jersey Supreme Court cases, Mt Laurel I and II. So let's talk about Mt Laurel I, the first Mt Laurel case, which was decided in 1975. And the court, the reading assigned for today, the summary of the court decision, it starts off by setting the context, giving you an idea of what this Mt Laurel Township looks like. And so Mt Laurel Township in 1975 is described as a flat, sprawling township. It is in between Camden, New Jersey, and Philadelphia. It was predominantly rural in 1950s, but by 1960s, the population doubled, and then it doubled again by the 70s. The court also comments or acknowledges that this growth had been driven by transportation improvements, and it has mostly developed through major subdivisions. The following slide will, what I'll talk about here is not covered in the, discussed in the assigned reading, but I think these are highly relevant facts for the case, for understanding the case. So the reason why Mt Laurel case was brought to the court was because of the series of events that I'll be talking about. So in 1960s, the 1960s in general was a decade of major development plans, and these developed through what's called planned unit developments, which is it's a different form of the community development that we started to discuss through Dr. Pendel's lecture. So these these planned unit developments have become highly popular in the 1960s. And also in Mt Laurel, there were 3 PUDs proposed to develop more than 10,000 homes and some commercial centers and industrial parks, all which will all sort of cumulate in Mount Laurel, developing into an affluent suburb. By contrast, Mount Laurel has had a historic Black community, most of whom earned incomes below the level of what would be needed to purchase one of the homes in the planned communities. At the same time, the town was cracking down on their code enforcement, which began to displace poor Black residents from their homes. So in response to all of these series of events, the Mount Laurel's Black community began to mobilize, and in 1969, partnering with a nonprofit developer, they petitioned to develop a garden style apartment homes. And this was to relocate the displaced Black families, but um, the as you may have expected, the township opposed to this proposal fiercely, and hence we have this case, the Mount Laurel case, in front of us. So the court next discusses the parameters, the broad parameters of the township zoning. So let's talk about that. The zoning of Mount Laurel, it's 30% zoned for industrial, but only tiny portion of that was actually occupied. And there were very minimal commercial uses. And then the remaining land was all zoned from R1 to R4, all of which only allow for single family detached homes. The court acknowledges that Mount Laurel had several PUDs, which had higher density housing, but that these PUDs were unaffordable. Specifically, the court notes that how the PUDs were designed to exclude or limit the number of families, and especially the number of children living in the community, to keep the property taxes down. So the New Jersey Supreme Court acknowledged all of the broad parameters of the township zoning and concludes that the intent of the township zoning was, first of all, to keep the property taxes low, and second, realistically only allow homes within the financial reach of middle income households. So with that finding, the court ruled that Mount Laurel zoning ordinance was unconstitutional under the New Jersey Constitution, and established a constitutional mandate. This should be constitutional. I'm sorry for the wrong language. They established a constitutional mandate that municipalities' land use regulations must create a realistic opportunity for the construction of its quote unquote fair share of low and moderate income housing. It is important to note, and as you'll see in the subsequent case, that the court does not give any guidance in terms of how this fair share should be calculated or how to ensure compliance of the municipalities. So that was Mount Laurel 1, and it made a huge impact, but also created lots of problems because, again, it didn't specify how this fair share should be calculated and how, who should enforce the compliance. And without the compliance mechanism, or I guess ways of tracking compliance and ensuring compliance, the first Mount Laurel case led to similar types of appeals in New Jersey courts all over the state. So what happened subsequently is that many Mount Laurel type cases have been heard by the courts because developers were essentially suing municipalities, arguing that their zoning does not allow for this realistic opportunity for low and moderate income housing. And so essentially the court essentially decided to group some of the Mount Laurel cases, including the second Mount Laurel case, together and hear the facts together. And the court retreated for a couple of years to deliberate and came back in 1983 to issue this decision. The court starts out by acknowledging, first of all, that Mount Laurel 1 did not provide any guidance for remedies and simply just ordered municipal compliance. which created lots of confusion and also waste of judicial energy at the courts, because there was a high level of uncertainty and inconsistency in terms of trial courts who are handling these Mt. Laurel cases. And also, even if it got to the appellate court, appellate levels, it was not consistently heard. So the court was responding to this judicial sort of dysfunction, first of all. And then second, the court also acknowledged that the first Mt. Laurel decision, after that, Mt. Laurel still remains really exclusive, and as with all these other wealthy suburban communities. So in other words, the Mt. Laurel decision really didn't make any substantial impact on the ground. So having acknowledged the two issues, the court wanted to, quote unquote, put some steel into the doctrine. And here's what the court did. So first of all, the court clarified that municipalities, the burden is on them to prove their good efforts to provide fair share of low and moderate income housing. So that was a clarification. And then this proof will need to be expressed in terms of hard numbers. That numberless solutions will not be accepted. And that in response to the judicial mess that they were seeing, they decided to designate three judges who will hear the same three judges who will hear the Mt. Laurel cases to build consistency. What's more important is that the Supreme Court acknowledged that simply removing regulatory barrier was not enough to create affordable housing or low income or moderate income housing, and that affirmative actions are expected from the municipalities. So it directed municipalities, first of all, to at minimum remove all the zoning and regulatory barriers that can deter the construction of affordable housing. And second, use affirmative devices such as density bonuses and mandatory set-asides. And this mandatory set-asides are, in today's world, is most commonly referred to as the inclusionary housing ordinance, or inclusionary zoning. It's referred to as inclusionary zoning as almost like an antithesis to exclusionary zoning. But I prefer the term inclusionary housing ordinance, as inclusionary housing ordinances are not always found within the zoning ordinance. Sometimes you find it in the general ordinance, or sometimes in the housing ordinance. So those are the two major directives that the court gave to the municipalities. And then also very important is that the court allowed, the Supreme Court allowed lower courts to issue what's called the builder's remedy. So what this is that if a trial court decides that the municipality has not met its fair share requirement, and that the municipality fails to revise its ordinance to comply, in that case, the trial court has the authority to issue a builder's remedy, which would grant the developers to proceed to build the project as proposed, despite the local government's opposition. So that was really powerful, and it obviously created a lot of backlash from the municipal governments, but at the same time, it was a highly effective measure for getting the projects built at the time. 2 years after the second Mt. Laurel decision, the New Jersey state legislature took an action. They enacted the Fair Housing Act of 1985. And it was a legislative response to Mt. Laurel cases. And first of all, it confirmed the fair share concept and provided some additional guidance for how to implement the mandate. it can be seen as a like a doubling down effect of having a constitutional mandate and a statutory requirement. The act established a state agency called Council on Affordable Housing, COAH, to implement the mandate. And it's interesting that the authors of the reading assigned for today, the textbook authors, question whether the builder's remedy was in whether the Supreme Court decided to put out there the builder's remedy so that the legislature would finally take action. And that seemed to be the case because one of the main objective of this Fair Housing Act seemed to be to minimize the judicial award of builders' remedies. And how this is to be done is that cities were through Fair Housing Act and through the creation of COAH, cities were now required to submit their affordable housing plan, or not, I'm sorry, not required. They were allowed. They were given the opportunity to submit affordable housing plan to COAH. And if their plan is substantially certified by COAH as a valid sort of attempt to create affordable housing, then this plan is presumed to be valid and constitutional, which would reduce or which would make developers' challenges much more unlikely to overturn or succeed in the litigation. And then COAH was also charged with calculating the fair share of low and moderate income housing. However, it did not do a good job, the Council on Affordable Housing. So almost immediately, as it went into effect, its critics have developed, and that included affordable housing developers, and on the one hand, and then municipalities on the other, and everyone in between. So a fair share formula was critiqued to be too complex and ineffective, and the COAH was critiqued to be inefficient and slow, and that the organization itself was seen as very deferential to municipal interest. So COAH has a very interesting history, so I want to briefly go over that, which I call the COAH saga. So COAH had first 2 rounds of rules, which went fairly well, and then by 1999, they were asked to adopt a new set of rules, the third round of rules, to calculate that fair share of affordable housing, low-income housing. However, they failed to deliver. So what they did when they failed, it was to simply extend the certified affordable housing plans of the municipalities, which resulted in a lawsuit by the affordable housing advocates in 2002. So COAH was then asked by the appeals court to adopt a new set of rules. COAH did. But this new set of rules substantially reduced the fair share obligations of municipalities. So in response to the reduction of obligation, the advocates sued again, and new set of rules were this new set of rules were invalidated by an appeals court in 2007. The court found that the rules violated the constitutional mandate as well as the statutory requirement. So COAH enacted a new set of rules afterwards in 2008, again to be invalidated this time by the Supreme Court in 2010. Supreme Court directed the COAH to revise the rules, but the COAH missed the deadline, and by 2015, the New Jersey Supreme Court said, you know what, this has gone on for too long. We're just gonna take the responsibility from COAH back to the courts. So that was almost, well, it wasn't the absolute end of COAH, but the COAH, the importance of COAH in implementing the fair share requirement was substantially reduced by this 2015 decision. And in 2017, the Supreme Court, interestingly, ordered the cities to make up for all the affordable housing units that were not delivered since 2000 because of COAH's dysfunctional history for that 20 or 17-year time frame. But not surprisingly, the battle is still continuing. And even now, the court, and now at the New Jersey courts, not at COAH, the towns are still towns, and courts and advocates and residents are still wrestling with this issue of fair share obligation. This quote from one of the council person is exemplary of the sentiment. There's a number. We don't know what it is. The court even doesn't even know what it is. The people suing us don't know what it is. So I think I like to tell the COAH saga because this just shows how difficult it is to implement a sound policy and a statutory mandate such as the fair share obligation. And this is particularly so when the implementing the rules that are designed to implement the statutory and constitutional mandates are complicated, and that the political leadership that's needed to support the implementation is always changing, and that the process in and of itself, because of its complication and delay, is prone to litigation. So so that is the story of New Jersey. I hope you enjoyed and got some takeaways from this lecture. I do want to leave you with two questions to consider. So first of all, considering how things panned out in New Jersey, how effective do you think are the state imposed mandates in redressing exclusionary zoning? Is either the legislative or judicial approach more or less effective, or not? And as a follow-up, what could have been done maybe differently to change the course of how COAH, how to change a course of COAH? And then the second question that I wanted you to consider is not necessarily discussed in the lecture, but I wanted to bring your attention to the fact that the plaintiffs in the Mt Laurel cases were the Southern Burlington County NAACP. However, race is not mentioned at all in the Mt Laurel decisions. And so I want you to think about why the court didn't acknowledge the racial implications of exclusionary zoning, and what were the likely consequences of omitting race in their decision. So I'll leave it at that, and I hope you enjoyed the lecture, and I'll see you in a couple others.